Hi, everyone. This is Jeffrey Wernick, and I'm here with Bruce Fein, which of course means it's the first Fine Points of 2025. I'd like to first start off by wishing everybody, I hope they had very good holiday season. I hope they had wonderful, whether it's Christmas or Hanukkah or whatever people celebrate, or just being alive and having some time off. And I wish everyone that 2025 will be the best year yet. The original intent for Bruce and I to speak today was we were going to review, which we will still have time to do, the Smith report that was issued, at least Volume 1. Maybe one day we'll see Volume 2. But there was a ruling this morning with respect to TikTok. It was a unanimous ruling. So I find it interesting, and we'll have Bruce speak about it. For me, the facts are pretty simple. Congress decided that they perceived TikTok as a threat to national security because of all the data that TikTok has, even though, from my understanding, their servers are in the U.S., and it's a U.S. entity that's operated separate from the parent. But the feeling is that basically, as if the Chinese government said, we want to look at everything, that TikTok would not be in a position to deny the Chinese government access to whatever the Chinese government wanted access to. And just that fact pattern, that the expectation was that TikTok could not say no to the Chinese government, even though there's been no evidence the Chinese government has ever asked for that access or been given access, that just the potential that could happen was enough to consider TikTok a national security threat, and therefore the Chinese either had to divest its ownership of TikTok, so would it be in American hands, or there'd be an obligation for the app stores to shut down and not make TikTok available. So this case was appealed. It was appealed at the appellate court in D.C., where Justice Ginsburg ruled on behalf of the Biden administration and Congress and the action that they took with respect to the banning or divestiture of TikTok. And now the Supreme Court unanimously has reaffirmed the bill passed, the legislation, and the prior appellate court ruling that reaffirmed that TikTok needs to either be banned or divested. We had the further announcement that Biden basically said is that he's not going to enforce if nothing happens, the Biden administration will not take any enforcement action against the parties that end up keeping TikTok on. If Apple or Google ends up keeping it in the Play Store and keeping it available, that the Biden administration will take no action. The action was supposed to be taken the 19th. I guess the 20th I guess it's January 20th that Trump will be the president. So Biden has basically passed this on to Trump, and Trump has said basically is that he filed something that basically said, I don't care what the court ruled. I'm a deal maker. Let me make deals, and I'm sure I could make a great deal. So, Bruce, I kind of laid up. If I've misstated the facts, please correct any misstatement I made. But now, given the fact that I hopefully have fairly accurately stated the facts, correct any mistakes I made, and then tell me what you think about all this.
Okay, you haven't made any mistakes, but I think I would add a couple of points that are important. Number one, and this is critical going forward, the government wanted to submit in its favor classified information that would be withheld from the opponent, from TikTok, in making the argument. This would have been the first time in the history of the U.S. Supreme Court where the litigant couldn't see the information and arguments on the other side. The court did not permit that to happen, said we're not relying on any classified information that hasn't been shown to the opponent, which as a practitioner, it's frightening to think I would go into a case and couldn't see what the other side was arguing. The second thing was that the court went out of its way, unlike the Court of Appeals, the Supreme Court, to say we're not affirming the statute's constitutionality based upon the Congress's fear that the Chinese government could manipulate algorithms to brainwash 170 million American users. Said we're not going there. We don't need to because we think the data collection problem was sufficient to pass muster. It's obvious that they felt very uncomfortable about the theory that you can suppress speech if you think the American people are too stupid to understand and evaluate it on its merits, and therefore they need a school marm to protect them from stupid speech. You can see that's a slippery slope that goes down very fast. Now, what I thought on the merits, Jeffrey, that was very, very slender, is this idea that with all this data that China could collect and access around the 170 million TikTok users, suddenly they're going to use it to recruit and blackmail and spy. I mean, I talked to people who worked at the CIA, said, is this the kind of information you collect on foreigners to try to recruit them as informants? Said, no, you don't care about the, ice cream. Ordinarily, it's money that you use. And there was some of the oral argument where Justice Kavanaugh speculated, well, even if they collect information when they're 10 or 11 years old, maybe 30 or 40 years later, they'll be in a sensitive government position and then you could blackmail them. I mean, that is really taking speculation to a new level, which I think is completely absurd. After all, before anyone gets hired in any of these intelligence agencies, they go through clearances. Did you smoke marijuana? Did you do that? So that if there was blackmailed information in someone's background, the idea that we wouldn't catch it before the Chinese is kind of absurd. So my take on the court's opinion is that this is further confirmation. We've entered the era of the empire. And anything the empire says is a national security risk, the courts are unwilling to second guess. They will accept the most ridiculous and stupid arguments. Now, the reason why, to me, that's important is because I was here in Washington at the time of the Pentagon Papers. You remember that was the 47 volumes of classified information showing Lyndon Johnson lied through his teeth. There was no light at the end of the tunnel anyway. All the government lies told that we were seeking peace when we were ratcheting up the bombing of Vietnam. And in that case, the Supreme Court also had an accelerated briefing schedule. It was in the summer of 1971. And the court 6-3 said, no, we're not suppressing any of this publication. And, we are not accepting your argument that the sky would fall, that there would never be any diplomacy again if you publish the information. And of course, the New York Times and Washington Post published, and no, none of the horribles that was speculated by the government happened. And indeed, the Solicitor General who argued the case for the Nixon administration in favor of suppression afterwards, his name Dean Griswold, Erwin Griswold, he was dean of Harvard Law School when I was there. He wrote an op-ed piece later, said there was nothing that was sensitive, that all the classified information was just to conceal embarrassment. And the national security argument was worthless. So you take, that's 1971. So we're 50 years away from that. And we've grown so much into the empire, national security mode, state secrets, executive privilege. It shows transparency is gone. We have basically a one branch government with no oversight by the judicial branch or the Congress. And I believe that if Mr. Trump continues to do what Mr. Biden does, namely say, I don't really care whether the law is there. I'm not going to enforce it anyway. Not because I think it's unconstitutional. I can't, because the Supreme Court said it is constitutional. But hey, I just don't like it. Well, if that was true, why do we even have laws passed? You don't even need to veto laws anymore as a president to try to get them from enacted. You just say, I don't like it, so I won't enforce the law. I mean, that's the end of separation of powers completely. To my mind, even if you couldn't get a judicial injunction forcing the president to require divestiture, it clearly is an impeachable offense, since under Article 2, the president is obligated to take care that the laws be faithfully executed instead of sabotaged. And after all, every president, including Mr. Biden and Mr. Trump, on January 20th will, under Article 2 of the Constitution, be required to take an oath to uphold and defend and preserve the Constitution, not sabotage it. And when you don't execute a law that you don't like, even though it's passed Congress, you haven't vetoed it, simply because of policy disagreements, you're flouting your oath of office, which in my mind is a catastrophe when you think, well, where does this stop? If he can decide he doesn't want to enforce the TikTok law, what other laws can he decide he doesn't want to enforce? Where is there a special neon light that says these are the laws that you don't need to enforce, these are the laws that you do need to? Process is everything about a government that's going to be under the rule of law and have checks and balances, as opposed to one-man dictatorship, which is where we're going very fast.
Well, it seems to me what Congress could have done, if Congress wanted to give, and maybe you can correct me if this is wrong, if Congress wanted to, I mean, Congress is already in business now. So they're meeting, they're holding these hearings, regarding the confirmation, passing laws. Congress could have said after this, Trump's going to be elected president. Trump was elected president. He's going to be president on the 20th. Congress could have issued a new law, right? Reversing the law and basically saying, we're going to allow the executive 90 or 120 or 6 months, to cut a deal. And if the deal is not done to the satisfactory of all the parties, then that would immediately trigger what we passed to begin with. So Congress could have conveyed these powers to the president, but they've chosen not to do so. So
not only that, Jeffrey, the president himself, who was communicating with Congress, he was intimately involved in the selection of Mike Johnson be speaker. He could have asked, hey, please, I'm going to be inaugurated. There's this TikTok case going on, and he knew it was going on because we had discussed it before in the Court of Appeals. And he could have asked them, please pass legislation that gives me this kind of discretion. He hasn't done that either. I mean, it's truly amazing. He just figures, I'm White House, so Congress is nothing. He selected Mike Johnson, really the House Speaker. This is the complete breakdown of separation of powers, which is the crown jewel of the Constitution.
How much of the this deference to the arguments regarding national security have the courts been more willing to accept that argument with very limited evidence or proof since 9/11?
Yeah.
Has 9/11 been an inflection point with respect to how the courts deal with these issues, or the courts have generally tended to be very deferential to the government when it made these claims? They would tend to give the government the benefit of the doubt, or has it been more so since 9/11?
Well, it's been more so since 9/11. But I say, if you take the baseline, which is the Pentagon Papers case, where the government lost, we're in the middle of an actual war then in Vietnam. And the court asked for evidence, and they couldn't find any, right? And their own lawyer basically said there wasn't anything to find. But I do think that it's not like, one big evulsive change, Jeffrey. Year after year, we get more and more into this empire bubble. Everything is national security. And the sky is falling, and we have to control everything under the sun. And that's witnessed after 9/11. It found expression most vividly in the Fourth Amendment area, where the court just threw up its hand, said you can spy on anybody for any reason, at any time, any place, not searching for evidence of crime, which is what the Fourth Amendment is about, trying to limit the government's ability to spy, to uncover crime, just to gather foreign intelligence. I mean, foreign intelligence means virtually everything under the sun. It's of infinite plasticity, which means that we no longer have a Fourth Amendment. And that's really due to 9/11, which is based upon this phony premise that suddenly our inability to collect or intercept communications amongst Al-Qaeda was the reason why they succeeded on 9/11, which Jim Banford and others who've looked at it showed that simply is not true. We simply had collected so much data, we didn't have the capacity to download and interpret what we collected in a politically relevant time span. It wasn't because we didn't intercept it, but the courts accept the contrary, even though the facts are otherwise, because they're so deferential to a national security state.
Yeah. When we're now talking about, and I don't want to say this is unique to Trump, because I don't believe it is, but we're reading, and it might also not be true that Trump will invoke this, but there's articles about how Trump will invoke executive privilege with respect to implementing a very broad, tariff policy, and also for some of the, maybe for deploying military, to reinforce the efforts for the promise he made for mass deportations. So are we sitting right now and seeing a continued erosion of basically the use of executive orders, and a pretext in many cases of what represents a real emergency, a national emergency, that would trigger the president to have these extraordinary powers, and that we're really diluting our Republican form of government, our constitutional republic, by just basically, governing through executive orders, and the courts confirming the validity of executive orders, that as long as they mention national security, that is the key words to basically let the president do whatever the president wants to do.
Yeah, I think that's an exact description. I agree with you. This is not just a Trump phenomenon. It has been increasing every year over long, long decades. The war powers, the treaty powers, surveillance powers, tariffs, you name it. The president acts on his own, and then Congress, they bark a little from time to time, but usually not very seriously. And they say this is going to be the end of our liberties and freedom. You cannot have a government where all the authority is in the executive branch, which, unlike Congress, is virtually always secret unless there are leaks out, and leaks ordinarily have ulterior motives to them, and remain free. People need to understand, people get attracted to politics in part because they're sociopaths. The people who are occupying and have the hands-on power are people who crave the ability to knock you over the head, to suppress you. They are tribal in their mentality. They don't see themselves as Americans. They're Republicans, they're Democrats. They have a certain faction that they're trying to promote. Those are the people, unfortunately, who get attracted to power. And that's the more important why you need separation of powers, to check these people. Those checks are vanishing. Now, I thought it was rather incredible, Jeffrey, that when Biden made his so-called farewell address a few days ago, he says, my gosh, there's been a concentration of power. Yeah, it's all on your watch, Mr. Biden. On all your years, you've seen it. And it's all accumulated in the White House, and you haven't resisted it whatsoever. So to talk him, and he makes references to Eisenhower's military-industrial complex and the farewell address of George Washington. But Joe Biden said, you're the one who created now what you're criticizing. So he's the last one who has any moral standing to speak about that. But it certainly is true that we are in a situation today. It's already, I call it, in a post-constitutional world. The president does what he feels he wants to do. One of the things that's very alarming, what Trump and the Doge Commission, which is the fraudulent representation, this is government auspices, which is private between Musk and Ramaswamy, is saying they're just going to ignore, this picks up Trump's idea, he'll ignore the court ruling on TikTok statute. We'll just ignore the regulations or statutes we don't like. For example, the Impoundment Control Act that says we cannot refuse to spend money that Congress has appropriated for a particular purpose. And then we'll just be taken to court. And it'll be so long before the court catches up with the illegality, we'll have achieved what we wanted to achieve anyway. But basically a complete attack on the obligation to faithfully execute the laws. There are ways to get rid of laws. You can repeal them. You can repeal regulations. There's process. There's commentary. There's back and forth. That's what the essence of civil discourse is about. And they've basically said, and we'll soon find out after the 20th of January, a few days away, whether there just be a wholesale attack on the rule of law, saying, fine, their attitude so far has been, well, let them sue us if we don't like the regulations. Well, that's not, the government can't work if you have to sue the government every day because they refuse to follow 200,000 regulations and all the laws on the books. It can't work that way.
Yes, I think this is I can understand that many people are frustrated because they think that there's too much, stalemate or too much polarization, and problems are not solved, and they just want problems solved. But the long-term consequences and the medium-term long consequences of basically ending the separation of powers, there's no point in having a constitutional republic. So I want to know how many people really just want to get rid of the constitutional republic and and have an election every 4 years to choose, a dictator for those 4 years, and have a dictator that has that basically cannot be impeached nor imprisoned, because they have complete immunity, and from not only impeachment, but for any crime they might commit, and vest somebody for a 4-year period of time with essentially unlimited powers in the absence of checks, and as long as people feel that they're kind of happy with that. It's kind of like the same argument, like, oh gee, I committed a crime, but look, I just won an election, so that means that people were voting to find me innocent of the crime that I committed. So that's can anyone who runs for public office basically escape criminal responsibility for any act that preceded them serving office because they won an election? That itself provides immunity for what they really are not entitled to have immunity about, which are actions taken, prior to them, being in office. So,
Jeffrey, you make a wonderful point, and I'd like to make this comment too. First of all, because that argument, Jeffrey, was invoked by Judge Merchan in New York when he decided he was going to sentence Mr. Trump to unconditional discharge, which meant he had a crime with no punishment, no probation, no fines, no incarceration, even for 24 hours. And of course, I don't understand how he thought a fine would interfere with President Trump's discharge of his duties. He'd probably be paid by Elon Musk anyway. But he made that kind of argument. Well, and that's the president's lawyers made there. Well, he got elected. He won. So therefore, the popular vote is the equivalent of a pardon. Well, just think, if popularity can acquit you of a crime, it should be able to convict you of a crime as well. So if you lose an election, then you go to prison. So I mean,
so.
now we have justice by votes, no jury, no admissible evidence. I mean, the process is everything about civilization. I remember there were arguments made when O.J. Simpson was acquitted of his murder trial out in Los Angeles, the TV spectacular. Well, we should just get rid of juries. Listen, no. We have human institutions. They're going to err from time to time. But you got to stick with the institutions, because the cure of getting rid of them is far worse than the disease. And that's, we have to resist the temptation to say it's imperfect, let's just get rid of it, without knowing what's going to replace it. If the replacement is worse than what you have, stay still.
Exactly. I think, with respect to Merchan, I think what Merchan had said in advance how he was going to rule, which was basically, you're a felon, but there'll be no consequences other than that it'll be permanently, indelibly in the record that you're a felon unless some court overturns what I did. I think, and even that was a 5-4 ruling. So I think Merchan decided to do that. I think his audience was the Supreme Court. I think if he would have not have declared his intention of basically telling Trump, the court, you had a trial, you lost, you were convicted, that we're not going to pretend that didn't happen. It did happen, and you can go. You're in your complete rights to appeal that conviction. But until it's appealed, and if you win an appeal, that conviction stands. I think that's what he was fighting for, Merchan. The integrity of the process, because I think if he would have done anything different than that, there's a good chance that the 5-4 would have been the other way, and and they would have ruled that Trump was not subject to any sort of judgment. So my feeling is that he did what he did with understanding that he had to make it friendly to the Supreme Court, not overturning the actions that were taken during the trial. So that's my best guess on why he did what he did and why he announced it prior, because he was announcing it knowing that Trump would go to the Supreme Court, and that he would have a weaker case if they said, look, or this is not going to make your life more difficult, because you don't have to go and figure out where you're going to get the money. You don't have to you got very busy with this transition, you know, you don't have time to go to the bank and wire some funds in. That there's too much, you don't have time to do that. So we don't want to burden you during this transition period, you know, and every minute you need to be available for the transition. So can't have you in jail for even 24 hours, you know, and we can't have you have to take any action that would be a distraction from your 24/7 activities associated with that. Because I think these judges on the Supreme Court would have found any excuse if they could have, you know, and maybe that would have flipped Roberts to the other side, you know, if there was, you know, this undue burden and the standard for what an undue burden could have been, you know, anything, you know, that would have taken 30 seconds would entail it being an undue burden. So I think Merchant was just said, I want the judgment to stand. He had a trial, had a jury trial. The jury convicted him, you know, and I don't want the Supreme Court to undo the work done by his court. And the only way to preserve that was this, you know. So, you know, because doing anything more might have then erased everything that court did. So
Yeah.
that's my speculation on why.
No, well, I don't disagree. That's logical. I think that, to my mind, where he was deficient, if he really felt that way, he still should have done more to show that that the Supreme Court of the United States had required a dual system of justice, because it wasn't just the 34 felonies, Jeffrey. We have a defendant who is totally uncontrite, voiced no remorse right up to the time of sentencing, was claiming this is a witch hunt, you're terrible, you know, you should be prosecuted yourself. Total disregard and attack on the entire judicial process. Yeah, I mean, that's really unheard of, you know, in the annals of sentencing. Very sad. And of course, these kinds of statements voicing no remorse ordinarily are aggravating factors in a sentence, heighten it.
Yeah. My feeling on that, Bruce, is also, I think Merchant doesn't want to give any excuse for any other courts that will hear the case on appeal to have him being accused of being biased or things. So I think that's why when he issued the ruling, he was very short. Just said, you know, the court did it. The court did what the court needed to do. You know, he's guilty. I'm making this ruling not in deference to the person, but to the office. You know, Godspeed. And he was out of there because I don't think he wanted to say anything. You know, frequently less is more. And I think the more he talked, Merchant, the more it would have been that Trump's lawyers would have used to basically say this judge was biased, and that they have to reverse the ruling, they have to reverse the judgment in the trial because of a biased judge. So I think he just decided to say as little as possible to not give more ammunition, you know, to people who he certainly learned about their behavior through the trial. So he learned how they use statements and twist them and use it to make these type of claims that they file and, you know, on appeals. So I just think he was very, I think he wanted to preserve the work of the court and decided that, you know, less is more, say as little as possible. And if you say as little as possible, do as little as possible, that's the only way that the work of the court will be affirmed, you know, by the Supreme Court and the appeals court that will hear, you know, this issue on appeal. So I think Merchant handled it, in my opinion, intelligently.
Yeah. Well, those are strong arguments.
It's a sad statement that this is what he needed to do in order to preserve the integrity of what happened in that courtroom. So we can't really ever say, no one's above the law anymore, because this court has put somebody above the law in multiple occasions, and, you know, not subject to the law and above the law, and you know, and justice clearly is not blind. So I mean, the principles that supposedly the Supreme Court, you know, it's on the door when you go in, or, you know, the facade there, you know, there are certain words, you know, to that effect. obviously they don't take those words very seriously.
It says, yeah, it's right down the block for me. It says in very large letters, Jeffrey, equal justice under law,
Right,
enshrined at the entrance of the Supreme Court. It's a very gorgeous building.
right.
Not anymore. That was the old days. Not anymore.
They gotta chisel that away and replace that, as long as they're occupying that building, they're not living up to that, equal justice under the law. So they threw that principle out.
Yeah. Let me just make a final observation. We can move on to something else, Jeffrey. I have to concede I wrote 2 letters to Justice Merchant in a very diplomatic way, but I think that certainly the law is filled with instances where dissents and reversals become the law. Perhaps the most famous is the one vote that Justice John Harlan Marshall cast in Plessy and Ferguson, saying that the law treats persons as persons, not as racial figures, and dissented from separate but equal. But it became the law years later. That's not the only instance, but that's one of the most famous. And one of the considerations I think that needs to be considered, in even if you are risking reversal of the Supreme Court, and I'm not as confident as you are that Chief Justice Roberts would have flipped, but maybe he would have. I don't know. He wrote the opinion in Trump versus U.S., which is some signal of his sympathy to limitless executive power. But to write a dissent doesn't mean, even if it's reversed, doesn't mean it doesn't have legal impact. It just means that if you're right, it may come back and carry weight in the future, which should be part of the equation as to how you ought to act. That's my only observation.
Okay, thank you for that, Bruce. So you want to move on to the report number 1 from
Yeah.
Jack
So
Smith?
it's a 137-page report that Jack Smith issued. Now, of course, there's nothing in the special counsel's regulations that say the report should be public or not. It just says you're going to prepare a report and submit it to the Attorney General, and the Attorney General decided to release it. If he didn't release it, we know the succeeding Attorney General would probably be Pam Bondi, wouldn't have released anything and be hidden forever. But to my mind, what was most extraordinary about the report was not only what I consider devastating evidence, basically all from Republican Trump MAGA people incriminating Trump in the crimes of January 6th, seeking to generically prevent the peaceful transfer of presidential power pursuant to the electoral votes as were decided both on polling day in 2020 as well as through 61 judicial contests, which Trump had a right to initiate. But the report goes on after it marshals this evidence to state that the special counsel is convinced that Trump was guilty beyond a reasonable doubt, which isn't customarily something a prosecutor says, because when you're not going forward with the trial, there isn't any adversarial process by which someone can defend themselves. So you put a question mark over that. Why would the special counsel make such an emphatic declaration? And I think if you want to talk about a reason for an exception to the rule, because he was charged by Mr. Trump and his lawyers as being a fraud, somebody they're going to prosecute, who was out there, who had no evidence. This was a complete contrivance based solely on Mr. Smith's alleged antagonism towards Mr. Trump as a person or his politics. And I think he felt, given the volume of speech attacking him as running simply a hoax based upon no facts, made him compelled to make this statement. If he didn't, he knew exactly what the other side was going to use president platform to say, this was all a hoax. There's nothing there. We're going to go pummel this guy now. See, he really didn't have the evidence. And they may prosecute. They could still try to prosecute him. So this is what I consider self-defense. But it's a sad day when our law enforcement and judicial system has plunged to such depths that you need to violate customary norms simply in self-defense. But that's where we are. The report it's in the public domain. So Mr. Trump surely, his lawyers had a chance to look at it before it was published. They complained they didn't have enough time. But listen, Mr. Trump and his lawyers can respond at any time they want if they think there are deficiencies in the reasoning and the arguments in the law in this report that was given. The second thing in my mind that was significant is what I thought was a rather anemic explanation of why they didn't charge Mr. Trump with insurrection. You remember that a Colorado Supreme Court decision after a 5-day trial found that there was insurrection on January 6th. And the reason why that terminology is important is because a person like Mr. Trump, who had taken an oath to support and uphold the Constitution, engages in insurrection, then under the 14th Amendment, Section 3, he would be prohibited from assuming a second presidential term. So that meant that to prosecute Mr. Trump for insurrection could have potentially disqualified him from the office that he will be inaugurated to on Monday. Mr. Smith says that I didn't charge insurrection because, after all, the charge hadn't been brought in 100 years. It was very, very infrequently used otherwise. And it was a novel case. And moreover, there are other crimes that he had committed that were not so pioneering. Now that, to me, almost proves the opposite. The reason why, I would say, Mr. Smith, the reason why there aren't any cases, because January 6th was the first time in 234 years that any president even conceived of any systematic effort to overturn the handiwork of all the poll watchers, of 61 courts, and resort to force and violence to prevent the counting of electoral votes that had been certified by states, Republican and Democrat, according to law. So, of course, it's going to be a pioneering case, because what happened on January 6th was unprecedented, not just a little bit, but by country miles. And moreover, I would reason, said, listen, if he's not convicted on that count, it doesn't mean that you can't get convictions on the other counts as well. There are 3 other counts. So, and it's oftentimes the case that a prosecutor will bring charges. Some are stronger than others and move forward. But I think that if you're trying to deter a repetition of January 6th, the insurrection charge is that's the arrow in the quiver that's going to have the greatest deterrent, because it uniquely provides for disqualification to re-enter the White House. And knowing the lust for power that people involved in this process are succumbing to, that deterrent is very, very important.
Agreed. Now, I think in the report, there seems to be some references that there were a couple of references that Trump kind of acknowledged that he did lose.
Yes.
So
on numerous occasions to show that this was deceitful. It wasn't that Trump had different viewpoints expressed. Well, I'd have to choose between this and that. All the people, even his own campaign people, who looked at this said, "You've lost." His vice president, his governors, everyone said, "You lost the vote." And at points they said, "Yeah, we did lose, but it doesn't matter. We're going to go and fight even if we did lose."
So let's look at the facts as presented by this report and other information out there, like the call with the famous call with Georgia, where he said, find me some votes. Okay, yeah. He didn't say, "I heard there's fraud. Can you double check everything?" He said, "I only need 12,000 votes. I'm sure you could find them. I'm hearing a lot of gossip out here that that there's it kind of reminds me of the call with Zelensky over a couple of people are telling me about this Hunter Biden guy, and maybe it's something you should look into. Do me a favor, look into this. meanwhile, I'm going to hold back the aid to you. I'm not telling you that, but that's my intentions are, because I'm wanting you to do a favor, and I'm going to see whether you're willing to do this favor for me or not. So
Yeah.
it's kind of like the
But
same thing
let me
about.
Jeffrey, it's worse than that. All Trump asked, just announce that you're going to do it. He says, you don't actually have to investigate Hunter. Just announce it. That's good enough for my political gambit, right? So very cynical.
So here it says, find me 12,000. Find me it was about 12,000, about 11,700.
700, yeah, 11,700.
So about the 12,000 votes. Go find me these. People are telling me that they're there. So if people are telling me they're there, they must be there. So you go find it. I don't have any evidence that they're there, other than a few people telling me that they must be there. So go find them. It shouldn't be difficult. So I don't know how that's an official act, because that sounds like a candidate. Maybe a president would call up and say, there's a lot of examples of people telling me that there's fraud out there, and maybe you should recertify, go through, do another audit or something like that. And that might be saying that's an official act of a president concerned about the integrity of election. But that his call was, find me these votes. They got to be there. You're just not looking hard enough.
Yeah.
So
but in Georgia, Jeffrey, they actually did do some recounts, and they showed that Trump lost by bigger margins initially. So they did do recounts, and
they did do some of this work. He knew they did some of this work. He knew that after they did some of the work, that they didn't find anything.
Yeah.
So I'm not. I don't think I know well enough the law to determine whether that call itself, was a criminal act. What seems to me troublesome of the things that, from what I had read, the most troublesome things are not that he was calling people trying to say, get me votes, come on, was the effort that was made with the fake electors. Why do you think there's been so little coverage of, the plot to basically overturn the election by, it seems from what I read from the report, one is, first I have to say, the president and the executive branch has no role in electors, so
Right.
they're not supposed to be involved. So I don't even know why this is even controversial, because this is all engineered from the White House, these fake electors, and that's not a privilege or a right, that they have. So that's all supposed to be done by the state government and driven by the state government, and the president has no role in that, and shouldn't be interfering with that process. But clearly, it was being engineered there. And it seemed to me that from what I read, there were two outcomes they were looking for: either having Pence accept those electors and then vote and giving him the electoral count victory and just declaring victory. So, so that was one outcome, or basically saying, we got to put this back to the states, where the state governments, the Republicans controlled more than half the states. And so the expectation was, if it was put back to state legislatures, since the Republicans had a majority in more than half the state legislatures, that the state legislatures would have affirmed him as president. So I guess it was one of those two things. But it seemed to me the preference was to accept the fake electors as the electors and give him the victory. Why isn't there more trouble over the attempt to do that?
Well, maybe it's a little premature, Jeffrey, because there are outstanding prosecutions in Arizona, I think Michigan, I think maybe Nevada, for the state electoral fraud under state law. They're not federal prosecutions, and they are still live because in none of those instances was President Trump named as a defendant. And so there may be reluctance before trials to create arguments about pretrial publicity and fraud. But surely, in terms of the magnitude in showing Mr. Trump's intent of totally defrauding the American people in the peaceful transfer of power, this was the one that's most extensive. It's not like, one phone call, one person. If you're grabbing a whole slate of electors, I mean, you really have to turn this into kind of a Godfather Mafia kind of operation, right? You can't, it's not one phone calls can't do this. And it shows, I think, how systemic the attack was on the process by which we provide for the peaceful transfer of presidential power. And this is, and I believe that if we can't trust,
what if we had, what if we had every state where the governor and the legislature were of one party, and the person who won the popular and electoral vote of that state, and every state where the president won contrary to who the majority party is in that state, if the majority party just undid the election by putting up a whole elector slate and saying, you know, we don't care how the vote turned out, we're just going to put our own pool of electors in because we can get away with doing that. So, you know, people really would be okay with that.
Yeah,
I mean,
you're exactly right. I mean, that would be because you can think of the ideas. The reason why you have a legitimacy and why they have these dates where you try to resolve the electoral vote winner, including the judicial process, is precisely to prevent what you described, Jeffrey. First, the legislature says, okay, we'll have a popular vote, we'll decide who the electors are. But if they vote for the wrong electors, we'll say the heck with it. We'll change the rules in midstream and say, now we're going to decide who the electors are because we don't like what the popular vote came out. I mean, that's the kind of thing that happens in China and Russia. You know, it shouldn't happen here. And I hope it never happens here again. But that was what they were trying to do with these phony states of electors, is to say the popular vote really doesn't count. Because I want to reiterate for our audience, 61 judicial decisions, all of them against Trump claims that there was some kind of fraud in the electoral process. Lost every single one before both Trump judges and non-Trump judges, U.S. Supreme Court, high courts, low courts, everywhere. Because when the courts asked, where's the evidence? There wasn't anything there. As Rudy Giuliani infamously said, we don't have any evidence, but we got theories, right? And theories don't win you in court. I can guarantee the audience. You cannot have real facts.
They were telling people they were telling the people that were calling that they had the evidence that they've never shown anybody.
Yeah, but they never showed it to anybody. Yeah. Now, Jeffrey, in the business world, would you tell somebody said, you know, I've got $1 billion in my bank account. Would you say, okay, I will accept that? Or do you say, hey, I need some proof, right? That shows, I mean, how gullible you just
in the business world. In the business world, what you do is you have a contract. In the contract, you make representations and warranties, and there are severe adverse consequences for making false representations and warranties.
Unfortunately, in the political world, isn't that easy? Because small politicians, or most of them all, lie regularly, so you can very seldom believe anything that you hear on the hustings.
Yes, it's very, that's why I think that every politician should, once they run for office, they should basically take an oath. And that once they say I'm a candidate, an oath saying to always tell the truth, and they should be subject to perjury charges if they say something false. And anyone who is a voter in the jurisdiction that they represent should have standing in bringing charges against them. Yeah. So therefore, they would have to be very careful about, you know, the things they express as facts versus the things they express as speculation and opinions. You know, you can't be a perjurer if you're just speculating or giving an opinion on things. But if you're stating something as facts that are just factually incorrect, you know, and that would not be very difficult to prove. You know, then you would. You know, then you'd think a lot more carefully about the promises that you make. You know, because you'd have to back them up. So,
and you know, Jeffrey, there's this argument, and you know, we talked about speech, the chilling effect. You know, well, we don't want a chilling effect. I want a chilling effect on saying falsehoods and lies. That's exactly what you do want to chill. And you remember the famous or infamous statement that J.D. Vance, you know, he was confronted with the fact that the cats and dogs weren't being eaten by Haitians out in Ohio. He says, hey, you promised you wouldn't do any fact checking. Really? Can you imagine that? He thought it was outrageous that suddenly that he would be fact checked. Wait a minute, he's a politician. He never encountered that before, and this is ridiculous. And can you imagine in any other profession telling hey, you don't get to do any fact checking? I mean, they laugh. You'd be out of that profession in 2 seconds. Politics is the only profession where that passes as the norm. It shouldn't, but it does.
Yeah, the most powerful, the fiduciary with the most power to have an impact on somebody's life in a way without that person's explicit consent is subject to the least amount of controls you have. So that's kind of perverse, and maybe one of the reasons why so many people are frustrated by the process and why it has so little credibility. Is it's not designed to be credible. It's designed to give or at least how the design has evolved from its initial design, in a way that that lets them accrue a lot of power, with limited really governance oversight. So and we're living through now, these consequences of and unfortunately the people like it if they like the candidate. So if people like the candidate, they just want to see things done. They don't really care about freedom and rule of law. People say those words, but the reality is the actions that how people behave, they don't really respect any of those principles. The only principle they seem to respect is getting someone who can as easily get the policies they want, done, accomplished, and how it's done, they don't really care. So, which means they don't really appreciate living in a constitutional republic until one day all their rights are evaporated, and then maybe they will wake up. But even then, they won't care very much. So,
that's right. I always say, Jeffrey, that you and me and our audience, we're the guardrails, against a plunge into dictatorship and tyranny. And I say it's not Trump or Biden or anything else. It's just the system is in that direction. And if we don't complain and stand up and push for higher standards, I can guarantee you it would go to the lowest common denominator, because there's nothing, there are no standards out there, amongst themselves that are going to raise it higher. I refer, Jeffrey, to an exchange that was made during Pete Hegseth's confirmation hearing as Secretary of Defense. And, there had been brought out the experiences of intoxication, and he had cheated on women and non-disclosure agreements and things like that. I'm not saying those are essential. The main points, which mine is, you got to comply with the rule of law, don't do illegal wars and torture and other things. But the senator from Oklahoma was saying, well, listen, we senators, we all I see people drunk all the time up here. We cheat on our wives, we've mismanaged businesses. So why should we hold you to a different standard than us? My response to myself was, because he's got a nuclear triggering that could extinguish the whole species. You got 3 million people, There are no checks. There are checks on you as senator. You have a limited term. But anyway, that was kind of the insouciant attitude that he had. Like, this really isn't serious business. And of course, it becomes more serious with Ukraine, maybe the attack on nuclear facilities in Iran. Who knows what's going on with China? It gets escalated all the time. Anyone who hasn't lived through the Cuban Missile Crisis ought to learn that when you're dealing with the possibility of nuclear war, there are no second chances. Once you're over that Rubicon, there's no going back. And that's why you need to be especially scrupulous about who has a role in deciding whether to elevate to that level.
Yeah, I think another when he had a reputation as being Americans at mayor, Rudy Giuliani, the previous version of Rudy Giuliani, the mayor of New York, when he began to help clean up New York, the statements that he made was, we first have to go after like these small petty criminals, like the people, the squeegee guys and stuff like that. They got off the streets and stuff like that. And he said, why do you prosecute what these look like petty crimes? He said, is because you have to build a respect for rule of law. So you have to start at the most basic elemental level and then go up from there. so that people would actually respect the law. So it seems to me that that version of Rudy Giuliani would have behaved very differently about the current applications of people saying this stuff's a witch hunt. People could have called him of engaging in witch hunts by removing squeegee guys who clean your windows when you were getting off one of the bridges or something like that from Manhattan to Long Island. So but that's what his assertion was. If you want to attack crime, start with the smallest crimes first, because you have to build a culture, that culture of rule of law. So
Yeah.
I don't know how we can just take a pass on all these things and then say we want a culture of rule of law, and then we take somebody who illegally crosses the border and they say, a lot of people are doing a lot worse stuff than me. Why are you picking on me? I'm not hurting anyone. I'm coming here. I got a job. I'm paying taxes. Why are you hurting me when all these other people, are getting are getting exemptions from doing things much worse than me? I've not caused damage to any third party.
Yeah.
So, and I don't want this to make a statement about immigration and talk about that, but more just the point of, if you disrespect the law of some laws, why should any laws have any respect?
Yeah, there isn't any. If you look in the federal code or the state codes, Jeffrey, there's not a hierarchy of print, bold print or whatever, that tells you, well, these are the ones we really care about and these are the ones you can wink at. I mean, the process is the process. And I'm not saying that we have the resources to prosecute every infraction, but if we can't, there ought to be a neutral principle that decides which ones prosecute and which ones do not a political principle or anything like, well, we just excuse certain violations of law. But I think Rudy Giuliani, in a different respect, exposes why the political figures are so disrespected. Because he didn't really mean that, other than he thought it would be good for his mayoralty. But he had to disavow that principle when it comes to getting presents, well, the heck with the principle. The White House is more important. So he did exactly the opposite of what he was saying. He ran into court and said, no, we don't have any evidence whatsoever. We got theories, but no evidence. But that doesn't matter. We got to fight. We have to do trial by ordeal, rather than trial by jury. And why did he get corrupted? Because he has this lust for power, for the sake of power. And that's exactly why you need checks and balances to prevent the Rudy Giuliani's doing what they would do without any checks. And I just don't want to pick out Rudy Giuliani. At one time, he worked in his offices, not under him, but over at the Justice Department during the Reagan administration. But that's the nature of the beast of people who want to acquire political power. They do not have any restraints other than, if I can lose power, I won't do it, but otherwise I will cross any bridge in order to keep power.
What were the points? I gave you my opinion of the points that I found most compelling in the in the Smith report. What are the points that you found most illuminating and compelling? And did you see enough there to make you agree with the statement that if they did go to trial, you think the likelihood that a fair jury would have found Trump guilty?
Yeah, I mean, to my mind, first of all, the key element of proof in many cases, and here, is the state of mind, a corrupt state of mind of the defendant. And I thought that the evidence was even more compelling than what they had elaborated in the report, because we have to remember, in terms of corrupt intent, that it began not just in a day or a week. Mr. Trump pursued this for like 3 months, right after November election, up until January 6th. Systematic. I mean, what other intent can you impute? They said, well, this is what you could argue on the other side. He was deceived. His lawyers gave him the wrong information, or this or that. I thought the case was even stronger than what they put out. And plus, you can come in and you can have reputation. It can be an element in terms of proving intent on a particular occasion. And Mr. Trump's entire life has been one of deceit. of power for the sake of power. And he displays that all of the time. I think that's the reason why he doesn't take the stand in his own defense in these cases, whether it's civil or criminal cases. And there's basic seeming stumbling block was, well, we have to prove that he intended deceit. Well, that's the entire modus operandi for an entire 3 months. I also think that they gave too little attention to what can be inferred from the fact that Mr. Trump watched the insurrection for 3 hours on TV, didn't do anything to call it off, nothing. That, to my mind, is ratification. He has all the authority to call out officials, defense, military, police, stop, and knowing the fact that his mega crowd would have acknowledged whatever he said, he could have issued a tweet. You need to stop now. Leave. Mr. Pence is doing the right thing. He never did any of that. And in the report, they suggested, well, maybe Mr. Trump really didn't know and didn't approve of how the January 6th insurrection was unfolding. I said, of course he did. He was watching it unfold. He has access to disclaim it for 3 hours and does nothing. I thought it was overwhelming. But I tell you, Jeffrey, the most disconcerting thing for a lawyer goes back to, I'm very reluctant to approve an idea that if you go to, as a prosecutor, you can stand up and say someone's guilty without a trial. That should be very, very seldom done, maybe once in 100 years. But in this case, where you're being personally attacked as running a witch hunt with no evidence whatsoever, and yourself being a possibility as a defendant, in a case cocked up by, Kash Patel or Pam Bondi or something, maybe this crossed the one line where it's acceptable, almost in self-defense from the justice system being tarnished by how it would be painted by Mr. Trump and his supporters.
It seems to me that if there's the case you're laying out also makes it, I think, less acceptable that with the facts that were available to Congress at that point in time, that he was not impeached.
Yeah. Well, remember, he was impeached, but he wasn't convicted.
He wasn't convicted.
And remember, and it got to go cynical. One of the reasons why he wasn't convicted was because, in the words of then Majority Leader Mitch McConnell, well, the civil and criminal justice system will take care of him after he's out of office, right? Then as soon as that happens, Mitch McConnell turns around and says, oh, now it's a witch hunt. You shouldn't be able to prosecute him, right? So even the impeachment acquittal is somewhat dubious, because I think at least Mitch McConnell and maybe some of his others thought, well, this was before the Trump v. U.S. immunity decision, said, okay, he'll still be held accountable. He won't get away scot-free. That proved not to be true. In part, proved not to be true because the Mitch McConnells undercut their own statement and went out and campaigned against the prosecution after they acquitted him of the impeachable offense.
Yeah, I think that I really thought this was a case that was important to be tried, because a lot of people believe that that 2020 was a fraudulent outcome. I guess you could say everybody who is part of this administration believes that, because that seems to be a criteria for being part of the administration, is to accept that as a fact, that he was the legitimate winner of the 2020 election. The best, this should have been litigated in the court of law, where all the evidence was presented under oath, not on a tweet or not on a post on True Social, where you can get away with saying whatever you want to say, and it doesn't have to be truthful, and it doesn't have to. You could be spreading misinformation or disinformation, and you could do it without consequence. You can't do that in a court of law when you swear and take an oath. And I think, as a society, on an issue as important as there being clarity and closure on 2020, that we deserved a trial where Giuliani and Trump and the Kraken person, Sidney Powell and Patrick Byrne and J.D. Vance could have brought in all the evidence that they said they had
Mhm.
to demonstrate that they won.
Yeah.
Okay. And because the difference to sit back and say we found issues with the election, and just saying, that maybe we don't know who the winner is, as opposed to having evidence that you won. So they claim they won, and he's not said just not only they won, but they won big. So his assertion is that he won by a landslide. He won big. So the issue is he's made those statements. He's claiming he believes those statements. There's some evidence that indicates that he didn't really believe the statements he was making. And we've never seen the evidence that he said he had to back up those statements. So I think as a society, we deserved him and all the people who said it saying, he won, and here's the evidence I have, as opposed to, well, I think he won, because I heard a lot of rumors about a lot of things happening, but I can't tell you one specific thing that was investigated and proven, the outcome that, that he won and that he won big. So I think it's a shame that 2020 will never be litigated where it should be. And for finality is that all the parties who have any contention, about who have made all these statements not under oath, get in court and make it under oath and see if they'll make the exact same statements in court under oath. So far, that's not been the case. So far, they're either not providing testimony at all, or they're providing testimony, as you pointed out, where Giuliani was telling people they had evidence, and then saying no, but we don't really have evidence. We have theories. So where do those theories come from? Where was the evidence to support those theories? Anybody can come up with a theory. The question is, theories need to be tested and proven. So that was, and they've raised a lot of money to test and prove those theories, right? I mean,
It's hundreds of millions. It wasn't because they couldn't pay their lawyers. It's hundreds of millions of dollars. Yeah.
So
One thing, Jeffrey, let me interject here. I think it may be a little premature, your lament, because we still have, several state fraudulent electorate claims, and Trump cannot derail those. They're state violations, but the basic nucleus of operative fact is the same. And we still may get complete trials, say, in Michigan, in Arizona, and perhaps in Nevada. So that would be, I'd hope that they would end up going to full trial. I hope they would televise those trials. So it's less than perfect justice, but imperfect is better than none.
well, yeah, we'll see. I guess he has no influence over those trials at all, right? On a federal.
It'd be like the New York trial, correct? And he got convicted of 34 felonies in that case.
So what's the schedule for the trial? Are there's any of them look like they're going to be trialed? There'll be the trials in 2025, or we're going to still wait longer before?
No, I think, well, being a lawyer, the judges and the emotions and everything, it could. I think that we're likely to get trials in the latter part of 2025, certainly in Michigan, and maybe in Arizona. But a lot of it depends upon attorney's schedule, how many defendants you have, whether there are any guilty pleas. Remember, we got some guilty pleas out of Georgia before the whole case went sideways because of Fannie Willis and the hiring her boyfriend and whatever. But I think that we will get something, certainly by the end of the year in Michigan or Arizona.
Yeah, the Fannie Willis. That's another one that I'll still. There was evidence that Fannie Willis offered the job to somebody else who was credible to everyone.
Yeah.
Okay. He decided to say no because of the consequences to his life from MAGA world if he said yes. People are not troubled by the fact that there's a deterrence from people assuming certain responsibilities because their lives will be threatened. And we don't, people think that's not a big deal.
Yeah, it's a huge deal. It's a huge deal to deter people from coming in and serving. And I mean, and that's, I've written it.
How could not a reasonable person sit back and she says, "Here I am. I'm Fannie Willis.
Yeah.
I'm having one of the, I'll have one of the most controversial. I'm out living in some other residence that I have to live in because my own life is being threatened. I try and get somebody prestigious to come and join this case. They won't join. Okay." And this is going to be a disaster for anybody's life who joins it. So, and I need to have somebody I trust doing this stuff. And maybe there's only a handful of people who I can say I really can trust. Why can't anybody think that that's a reasonable narrative? As opposed, the narrative that's being spread that's disqualified her is saying, I have no case here, but I'm dating this guy. He's not making enough money. Let me fabricate this case and pay him some money so I can pay him some money. So, I mean, that's basically the arguments the courts have accepted by removing her.
Yeah.
I mean, am I saying anything that's not true?
Well, you've admitted that not only was the case not far-fetched, we have very prominent Trump attorneys like Jenna Eller pleading guilty, and another one as well, because they did have a strong case. You don't plead guilty if you're a Trumpist if they don't have any evidence against you. So it was not a concocted case, and she's won repeatedly in efforts by Mark Meadows and other high-profile defendants to get the case thrown out. It was before. Now, if she doesn't take the case, then it may go to someone else who may drop the case. But it's a state case, and Trump can't directly interfere. He's kind of earned enmity by the governor because of all the things that were said when they refused to flip the state for him in 2020.
But she's been removed now, so we don't know what's going to happen.
No, but she'll be replaced. There's a mechanism for replacement. It may be like Archibald Cox was fired, and Leon Jaworski stood in his shoes and prosecuted. But we don't know whether we're going to get a Leon Jaworski to replace Fannie Willis. I don't know how the system works in Georgia.
What is recourse does she have? Does she have any appeals available to her to challenge that ruling that disqualified her, or she's not left with any recourse anymore?
There really is not any, because you don't have a constitutional right, to prosecute a case. So I think unless the politics there changes, I think that it'll be handed over to some other prosecutor who may or may not move forward. We don't know on that score. But listen, the larger point, I think, Jeffrey, that's important is when you deter very, very competent and stellar lawyers from taking cases that are needed to be above suspicion because they worry about they're subject to personal attack and the family's attack. That's really, really shocking, because it's precisely at the high profile cases where you need the greatest talent so that the public has confidence that justice was served. And this is very disturbing. And that's why it's going to be important to see what happens with Jack Smith and the Trump administration. Are they really going to, even if they don't convict him, are they going to start issuing subpoenas and grand juries going after him?
What has anyone? I haven't been following the confirmation process.
Yeah.
So, like with Bondi, has anybody asked what she's going to do about some of these cases? Like, will they give instructions to the documents case? There's still the two Trump employees being tried. Nobody's asked her what her intentions are regarding that case.
I mean, they're going to shut it down. There are two possibilities.
She's been saying a lot of things. I can't really address hypotheticals, but this is not a hypothetical.
It's not a hypothetical. No, it's not. No, they didn't push her. She just decided, well, I'll just do what the right thing to do is, because they also asked her about, she's going to go after the enemies list that's on painted in the book of Kash Patel. He's the FBI director designate. And she just says, well, I'll just do the right thing. And they don't press her on that. I mean, if I were there, I'd say, Miss Bondi, this is not a hypothetical. I'm giving you something that actually happened, and you put yourself in the shoes of Archibald Cox and William Ruckelshaus when they got a call from the White House on October 20th, 1973, saying the commander-in-chief has given you an order to fire Archibald Cox. Now, that's very specific. Would you have fired Archibald Cox? These are well-known facts of what happened. Would you fire or not? Or would you say, I don't obey illegal orders? They didn't do that. When they tried to get her to say whether she'd follow, she just hedged it and says, well, my president will never give an illegal order. Really? That's a hypothetical. I'm telling you, assume X, and this happens all the time in expert testimony, and tell me how you would react. She wouldn't answer that question.
How could she say that when we already know that he asked Pence to do something illegal?
Yeah.
And and actually, I read one book where somebody was talking about the fact that when he was in meetings in the White House where he says he was present at these meetings, and when they were talking about that one of Trump's ideas, to secure the border was doing a moat and filling the moat with alligators and poisonous snakes, so that people coming over would have to cross and have to figure out how they survive, swimming through the alligators and the snakes, and have the moat be very deep. So, if somebody wants to build a tunnel, they won't be successful building a tunnel. So that was a thing. And then he also said, one of the things he also said was that why doesn't the Border Patrol just start shooting people at the Mexican side? So when they see people approach the border, just start shooting them. And according to this person, what Trump was told at the meeting that that was illegal, and then he said, well, don't worry, I'll just pardon you. So I've heard one version said he was joking, and another version said that this whole conversation was made up. So even though from what I read, there was more than one person who's confirmed that this conversation happened. So how could you say, with this information being known, how could you say that this person would never ask anyone to do something illegal when there's go find me votes that don't exist? That's asking people to do something illegal. Go doing all these phony electors. That's illegal. So
Jeffrey, let me jump in here, because there's even more of a smoking gun. Jeffrey, the smoking gun that you're referring to, Jeffrey, the smoking gun on the morning of January 6th. And this is not made up. This is undisputed testimony of Mike Pence. Mike Pence has testified, and Trump is not disputed. Trump told him, Mr. Vice President, today you have to choose between me and the Constitution. So Trump made that distinction. Choose between me and the Constitution, right? And then when Pence said, I'm choosing the Constitution, then Trump said, he's not going to save us. He's doing the wrong thing. So here we have Trump recognizing he was asking Pence to do an illegal thing, because he differentiated between himself and the Constitution. And that's unrefuted. Aside from the fact that we know from the prosecutor's report, again, evidence has not been disputed, that when Mr. Trump was alerted to the fact that Mr. Pence and his family were endangered by the insurrectionists, he said, so what? I don't care. You don't think that's giving a tacit illegal order to kill or murder the vice president and his family?
And the person, and he was convicted of financial fraud with this, his filings with the bank. So he's been convicted of this harassment of Jean Carroll. So there's a lot of evidence out there. How can someone take seriously a statement saying? And the questions she's not being asked is what he will ask her to do or not to do, is what she will do on her own.
Exactly.
So that's evasive, and the fact is she should not say, I'm not going to be in that position. What she's asserting is she's never going to have to make that choice, because he's never going to put her in a position where she's going to have to make that choice. So that's basically her statement. I don't know who believes that statement. Maybe a few people believe it, but but that's not the answer I would want to hear. I
But
don't want to hear that I don't want to hear that I don't have to worry about you because you might behave badly, but you're not going to behave badly because the person who you report to is never going to ask you something where you're going to have to check and see what your own values and principles are. I want to know from you, independent of what that person is, are these things that you're going to do? And if somebody does ask you, what's your limits and what you think you're going to do? Don't tell me the answer of what that person will do. You have no control over that person. You only have control over yourself. So tell me about what you would do, not tell me about the fact that you're comfortable that the other person who you have no control over would never do that. I mean,
yeah,
that to me, I would be if I asked any question to anybody like that, I'd be very dissatisfied with an answer because the answer tells me nothing about what that person will do, other than the fact is that other person will know that they'll never be in a compromising situation because the person they work for will never put them in one, and so it doesn't say that if they put them in one, that they'll do the wrong thing. They're just trusting that that person will never put them in one. And that doesn't tell me anything. They control their behavior. Whatever people ask people to do and not people to do, I have no trouble if somebody asks me to do something and I say, NFW, no fucking way. And, will I do it? If I don't want to do it. So I'm an independent agent and I do what I want to do and don't do what I don't want to do. So, and I'm responsible for it. I'm not a slave to somebody else's requests of me. And her as Attorney General should not be a slave to anybody's request to her, that she's supposed to act independently, and according to fulfilling her oath of office, like they all do, is to uphold the Constitution, and that's her job. And whoever asks her, the answer should always be, I'm going to do this because it's what the Constitution says, and whoever asks me is irrelevant. So
yeah,
that's
you're exactly right.
how does anybody accept these answers?
Yeah, I agree because I mean it's stressed to me when I served in the government. Said my client, my client is the United States Constitution. That's what I took an oath. It wasn't to President Reagan or President Nixon or President Ford or Jimmy Carter. It was to the Constitution. So the proper answer is, listen, my oath is to the Constitution. If an order is unconstitutional, I'm going to flout it because my oath to the Constitution is superior to who happens to occupy the Oval Office. That's the right answer. She refused to give that answer. And the other element that comes into play, to my mind, is when you're talking about serving as a cabinet level, the standards ought to be, well, you're not a criminal, therefore we support you. You need advanced. You don't want to take certain risks. There's somebody who refuses to say, I will never obey an unconstitutional order is a risk because they may get an unconstitutional order. There are risks they're going to follow it anyway. So they say,
Right.
Listen, we're not taking that risk. Maybe you would, but you're not saying to us right now, giving us confidence that you would not obey a clearly illegal order like Elliot Richardson and William Ruckelshaus refused to obey on October 20th, 1973. And if you're not giving us that level of confidence, you're not going to get confirmed. We want somebody who's certain to obey only one superior, the Constitution of the United States. And if we don't have that confidence and it's not you, we're voting against you. That's how this should have happened.
When you were telling this, it reminded me of a story about when I started, my career. Young guy, I ran the bank balance sheet of a very large bank. Yes, I was 24, 25 at the time, and so when I got the promotion to basically be responsible for running the bank balance sheet, one of the things I had to do was price loans and price. And set the prime rate and things like that. So when I got the job, I asked, how do you change the prime rate here? And they said, well, we never like to move first. We like to wait for two money center banks to move, and then we do that. So I went to check with human resources, and I said, I have this job title, I have these responsibilities. I want to know how much discretion I have over the prime rate, and there were no restrictions. So the first time I decided, I had this model that was modeling out the money supply. I was doing surveys, and it was pretty active. It was pretty accurate. So I was doing a pretty good job of forecasting Fed policy, and so I wanted to move the prime rate sooner, so I would get the benefit of the higher interest rate over the weekend, because 3 days is, the 3 days for be able to price it Friday, Saturday, and Sunday is consequential to the earnings of the bank. So I changed the prime rate. So I was the first. The bank was the first bank to move the prime rate, and moved it before any of the money center banks did. So the chairman calls me and said, Jeff, I had this conversation with you, and I told you we have a tradition here. I said, yeah, I know there's a tradition, but I don't see where my obligation is to honor that tradition. I went to human resources. I have this authority, and I exercise my own authority. And they said, well, you shouldn't have done that. And I said, look, it's your prerogative to fire me, but I'm going to do whatever I want, whatever I think is the right thing. You're not your name. You might be the signatory of the paycheck that comes to me, but ultimately the shareholders are paying me, and I think the shareholders would like what I did. So, and their representatives are the board members, not and you're just one member of the board. So, convene the board, and if the board thinks I acted inappropriately, either you or the board can fire me. So, so they convened the board meeting, and they brought me into the board meeting, and so they said, Jeff, can you explain to us why you did what you did? I said, I did what I did because it was in shareholders' best interest for me to do it. Your job is to represent the shareholders. I did my job. Now you got to determine whether you're going to do your job representing their interest. You're going to tell the shareholders we're so dumb, we got to wait for 2 New York banks to move to increase the interest rates because we're too stupid to recognize when interest rates should be risen. If you want to go tell the shareholders that you have delegated the obligation to other banks because you're too stupid to do it, go tell the shareholders that and see if they like you protecting their interests. I'm not that stupid, okay? So I think I'm smarter than those banks, and I think I've proven it. So that's why I did it, and I'm going to continue to doing what I think is best, and what you think really doesn't interest me very much. And I walked out. I didn't even listen to what they had to say. I know I did go to my office, and I called my wife, and I said, expect me home soon because I'm going to get fired any minute. So I had the expectation that they would fire me, and they didn't. But but I felt I didn't work for the president of the bank. Everybody for the bank works for the shareholders.
Yeah.
So that you're a fiduciary. And, so the question is how do you fulfill your fiduciary obligation? And what happens if somebody who is a higher senior person in the organization has you do something that's a conflict with your fiduciary obligation to the people who you really represent, which are the shareholders. So for me, I was doing what was in the shareholders' interest, and I didn't care what the CEO of the bank thought. If the CEO was incompetent or didn't really care about shareholder interest, and would fire me because I gave priority to shareholder interest, I could live with that. What I couldn't live with, was doing something, that was not of benefit to the people who I represented. And people, really need to think carefully about the fact is, as the Attorney General, their constituency, they don't represent the president. They represent the Constitution and the people of the citizens of the country. That's who they represent. Okay, that's their boss. People used to say, I'm a public servant. I serve the public. Okay, I don't serve the president. The president nominates me. Okay, so I was hired by somebody at the bank, but ultimately, when I went to work, I did what I thought was in the best interest of the people I'm a fiduciary for, and I'm not fiduciary on behalf of someone who's senior in the organization to me. I'm senior to the people who are the shareholders, and those are the people I have to represent. And if there's a conflict, I have to choose which side I'm on. And I was prepared to risk my job to choose the right side. I chose the side of to understand that I had a fiduciary obligation, and everybody who was appointed to the cabinet should be clear that their fiduciary obligation is not to the person who nominated them, It's to the people once they get in their office, and that's their client, is the American people.
Yeah, and I think that it's what I describe is we've got a politics, or thinking about politics in terms of personalities rather than process. Politics is about process if it's to be elevated more than just mob rule. And the sanctity of the process is what we need to protect here. And you're exactly right. Once you throw that aside and, well, this personality, I just trust him, you're never going to get the power back. Once you go down that road, then whoever has the AK-47s wins. It's like Pastor Niemöller, who has spent time in the Nazi imprisonment camps, said, well, first they came for the socialists, but I was not a socialist, so I said nothing. Then they came for the trade unionists, but I was not a trade unionist, so I said nothing. Then they came for the Jews, and I was not a Jew, so I said nothing. Then they came for me, and there was no one to speak for me. So you got to stick up for the process and the rule of law. Once you make an exception, it's only a matter of time before the whole system is crushed.
I agree. Any final words, Bruce?
No, I think that, listen, we want to continue not to have, I think, different standards. I think that's what you and I try to do for Trump or Biden, Democrats, Republicans. The process is everything. But I want to underscore, ultimately, repeat what we said. The guardrails against a dictatorship and a wrongful government is us. We can't rely upon other people. If we're inert, we're going to get what we deserve, and that's unfortunately going to be a loss of all of our freedom and liberty that we will come to regret. And I can't say that strongly enough, because I'm in Washington. I don't rely upon those people on the Hill. I meet them every day, and I said, no, you're not the one I'm trusting to protect my freedom. I need to speak to my colleagues, citizens of the United States. I say that's the highest office of the land, citizen of the United States, because ultimate sovereignty belongs to us, and we need to act with that understanding. That's all.
Agreed.
Yeah.
Thank you so much, Bruce.
Okay. Thanks, Jeffrey. See you soon next time.
Bye.
Bye-bye.